We're going to talk about the law. Hey, close that door. Don't let that door. Okay. Close the door. You can lock it. Thank you, Mr. Medina. That's how you get it in class. Help me. Bam. And me and all of it. Bam. All right. So what do you do in a pre-law? When the case somebody walks into your door, you want to do pre-lawsuit considerations. Kind of give you some theory. I'm not about to go to this. Look, what do you do when somebody walks into your door? Oh, we try to keep you out of here. What actually? So you're identifying the facts. You're saying, okay, once you get those facts, you're saying, okay, now I know kind of cause of action. I know the claims. I know what this lawsuit is going to resemble, right? And so, all right, sorry. So, you as paralegals, and I hope that you get to this point. In my law firm, you will, because I will make you do it. And I supervise you all this. But you're going to interview people. And you're going to sit there and interview and you're going to say, all right, well, 5 W's and H's, right? Back to grade school. Who, what, when, where, why, how. Who, what, when, where, why, and how. I don't know what PowerPoints that I put on. Are PowerPoints on Blackboard?
Yeah.
Yes.
Which one?
1, 2, 3.
Okay. Is this it?
No.
Is it? Is it this?
No. It's different.
Yeah. Okay. We'll get to that in a minute. I typically don't read my PowerPoints. Okay. And it's not a really chronological sequence of notes from the PowerPoints. It's kind of like you just talking. Simple. I talk. You have to kind of like it's like mix and match. All right. I try to be more organized, but it's just kind of like it's hard. It's not my personality because we start talking about other things and then we move. But so, what constitutes an interview? The paralegal and the client, and then we all sit down in the room. Or now, we just do it over the phone or via email. I've seen probably half my clients in person. And we're halfway through the case, and I don't know what they look like. Well, I'm not driving out the valley. Okay. So, but you bring in the case. You identify, I didn't know the facts. You have to get the facts from the client. I do plaintiff's work. So, most of the time, we kind of just, plaintiffs will talk, like me. Just ramble. You have to streamline them. You have to streamline them and say, hey, what is, I don't want to know about your mama. I don't want to know about what you did when you were 7. What I want to know about is, tell me what happened in the case and what led to the facts. I need all the facts. And what we need to let them know, that this is an attorney-client privilege. Even if they don't retain us, it's attorney-client privilege. Even if they don't retain us, it's attorney-client privilege. So we have to make them feel comfortable. We have to make them feel like they can disclose everything to us without any repercussions. We're not going to tell their secrets. We're not going to let another attorney or the defense side know, oh, you know what? Hey, they really did this. That's what we have to do. And we have to identify that, tell them at the beginning, this is attorney-client privilege. Has anybody declined an interview before? Have you sat with the attorney or you did it by yourself?
Well, it depends on what the case is about.
Okay. By yourself? All right. No time. Litigious. And how, as a client, how did you feel?
One very, very helpful is supposed to be a top-rated attorney, but we have craft for English social skills. The other one, very, very good. I tell my children, ask questions, and it was really helpful.
Okay. And very important because you have to be comfortable. We have to make the client feel comfortable so they can trust us. It's a relationship. It's a relationship if you're litigating it now with the budget cuts going on 3, 4, 5 years. Yes, sir.
My understanding of a lot of very ladies have social skills, but they don't try.
You just don't have any social skills.
In terms of developing a relationship, building a rapport with the client, you're kind of the one that has the most contact with the client. And I've seen a few different attorneys in different areas, and some of the top-notch attorneys seem to have a social skills.
Well, I would say it's probably a case-by-case basis. I know some really good attorneys who have some really good social skills, and then I know some really good attorneys that don't. And I know some really good teachers that have really good social skills. I mean, it's a really, who you actually ran into that day type of deal. And so but I also know some paralegals that were terrible in communicating. But they knew the hell out of the civil. They knew the hell out of the rules of civil procedure. Though. I mean, they can find out what CCP 144 and everything like this. I'm like, ooh, thank you. But talking to them is like, oh my God, just get to the freaking points, right? And so, I don't know. I wouldn't paint it with that broad of a brush. I was just making a very subjective review. And some of us are pompous, right? Some of us, and we don't want to have to deal with things that we think are beneath us in the sense of talking to the client. Okay, and so if that's the case, if that's that attorney, you're probably going to get a bad social skill. I would tell you, I want my paralegals to do the initial client interview. I don't have time to do it. I don't feel like I'm better than it. I have motions to draft. I have an opposition to motion for summary judgment due on Friday. I don't have time to talk to the client, the new client, about what the case entails because it might not lead anywhere. So my time is money, and everybody gets paid if we make money. So I don't have time to do that. So you might have just got a situation where he just didn't have time for you. He thought he wasn't important enough for it. He just didn't have some skills. But I wouldn't paint with a broad brush. Anybody else did the client interview? Angela?
Yeah.
And did you do the client interview, or were you getting interviewed?
No, I did the interviewing.
Okay, what type of case?
What type of case? Breach of contract, general business litigation.
Okay. And was the attorney sitting with you?
No. He would sit in for more complicated stuff.
Okay. And so you took all of the basic information. Yeah.
When did this happen? Who did it happen with? To make sure that we weren't obviously representing the person. They were having an issue.
Conflict of interest. Okay.
How long ago did it happen? The whole story. We were in business together, and we were friends, have this agreement, and then, I couldn't pay anymore, and he said it was fine, the whole, and tears, and
They cried?
No, but
I'm just
ranting, and,
crying is good.
well, your tears, it wasn't so unfair.
And what's interesting about that concept is I don't have patience for that. I kind of like. So you see, kind of like you start crying like this. I gotta go. I can't deal with crying. I don't know how to. I don't know how to deal with it. I like crying. I'm like, my daughter starts crying. I'm like, I'm pondering. Do I spank her or do I just let her cry? I'm sitting there like, what are you crying about? The sky is blue. I don't know. I don't know. It's hard for me. So, but clients do that. They have all these emotions. They have all these different reactions, right? And we have to, you as paralegals, especially, but us attorneys too, have to be able to deal with these emotions. You have to be able to be patient. You can't be like, why are you crying? You can't do what I would do. You have to be able to manage that because we need this case. And they were harassed. They were sexually harassed. They have emotions. They have feelings. Right? And so we have to find some type of patience in ourselves. And so I'm sorry. And so look at this. Did you read from my script, anybody? Answer? Script?
No. Notes.
All right. Information report. The easiest way, and I don't know if this is posted. I try to post all this stuff. This is the kind of information report. Now, every law firm has something similar. This one is for personal injury. And so, if you look at it, you see we need all of this information. You say, why do you need a Social Security? Well, you probably don't, but you do at some point to compare it against the notes that other people might have when the defense start producing. You want to make sure this is the actual person, or this is not even your Social Security. So, and just kind of look at it. I'm not going to read from it, but you see it's very in depth. Talks about the date of the injury, time of day. Was it nighttime? Was it morning? Was it raining outside? Where were you at? The weather conditions. Who caused the injury? If you got that information, this is still personal injury now. Now I have one for employment law. I have one for breach of contract. And so to make it easy for my paralegal, I said, look at the questionnaire. Now you can talk to them, but kind of follow this. Make sure you get all of these portions of the questionnaire filled out. Witnesses to the accident, if any. General description of what happened. Accident reports. Insurance. Personal history. Marital status. Military service. Children. Other dependents. Go to general damages. Right? What's general damages? Act like you were tourists. Act like you were tourists. Pain and suffering. Good. Emotional. We can't quantify it. But I know I have children and I hurt my back and I tore my knee. I can't pick them up anymore. I can't show that love. Right? Also consortium. Tore my ACL. Me and my husband can't walk down the street. Me and my wife can't walk down the street anymore. Or my husband, whatever. Look, so we can't walk down the street holding hands anymore. I tore my ACL for 5 months. Right? We can't have any emotional connection anymore. Loss of consortium. I mean, so you look at all these and you say, well, why do you need to know all this? Why do you need? Because it goes to something in the case. One, we have to prove the elements. What's the elements of negligence? First one. First one. Duty. Breach of duty. Causation. Damages. Look, I got you know. Right? And under causation, we have 2 sub-elements. What? Why are you looking at your mouth? Actual causation and proximate causation. Actual causation, what for you crashing in the back of me? I would not have been injured. Proximate causation, the injuries that I suffered were foreseeable based upon an accident. Right? You wouldn't. Some of you. Act like you were in towards.
It's been a little bit. Gotta get that.
Yeah, you see litigation towards negligence like that.
Multiple choice.
So what we're doing is we're getting all of the facts to meet the elements because we have to prove each element of the cause of action to have a viable cause of action, right? So we're getting all of the facts for those cause of action. This is what we do in the initial client investigation. Okay, we're going down. You receive public assistance. That's for purposes of damages, employment. How much did you make? Did you miss work for 2 months? What kind of damages are those called? Special damages, things that you can actually add up and quantify. Alina, things that you can add up and quantify. So we didn't know how much you made. We didn't know how much where you worked at. We got to get you paid back. You have to make that money back, right? So that's what we look at loss of earnings. Any damages from this accident, including the car, vehicles, we need to get that fixed. Medical, hospital, doctors for diagnosis, because we need to know who our experts are. So you read this stuff, and I know you kind of like, man, this doesn't make sense. Keep talking. It all really has a purpose. It all really serves a purpose. Maybe not initially. I mean, you need to know the address to get paid, right? But maybe not initially. Why I know the doctor? But at some point in the litigation, if I have all this information figured out, it makes it that much easier going forward, so we can know what we have in front of us. And it's the same thing. Were you contributory negligence? And so California follows what type of negligence, contributory negligence statute? I love it when you guys look at me like what you're talking about. Comparative negligence, right? And so we're looking at comparative negligence, and you have these pure negligence, and so say, okay, if you were 30% at fault and they were 70% at fault, then you have a reduction in the actual amount of money that you're receiving based on the amount of fault, right? Comparative negligence. If you have a contributory, not a lot of most jurisdictions, I think it's like 6 or 7 still follow from complete contributory negligence means what? Yes, you 1% at fault. It bars any recovery. You don't have that in California, luckily. So you need to get, okay, did you make a left-hand turn? Like I have a case where my client lied to me. Clients lie too. They messed up the case and they lied. It really hurts me. I took the case, just something like this, and I don't follow it when I'm writing. Right, chicken strap, my sister that was struggling to read my writing. They hit us, we were making left-hand turn, they hit us, and it was their fault, my light was green, they just ran through the light. Oh, that's a really good case. Trust me, I mean, it was obviously more said than that. But find out, you look at where they got hit. It's impossible for them not to try to run that red light and make that left-hand turn and get hit like that. It's not possible. They got hit in the front. So that means the light turned green going this way, and they were trying to beat the red to make the left-hand turn, right? Unless that person just said, that person was at a dead stop, I'm just going to go on a red light. I mean, which is hard to believe, right? And the insurance company didn't believe it. But I took a case and I got on the doctors and I'm set up and I'm like, how do I take this to trial? How do you take that to the trial? Sorry, I say shit a lot. Shit. There we go. Okay. How do you take that? And it was a shit case. And he put me at because he lied. He lied and I trusted him. And even it wasn't a police report. That would have helped. Accident report, obviously, the police didn't come. And so anyway, so clients lie. And so that's why you have to make them feel comfortable. Like, you have to tell me the whole truth. This is a attorney-client privilege. I would never disclose this to anybody. And we never built that relationship. Yes, sir.
So you do in that case, if you have a shit case.
Shit.
And, right, exactly. You're still representing them. That one's already invested time, money, medical expenses. It's contingency. You don't want to go to court, and they want to go to court. Well, I know that way.
The client wants to go to court?
Yeah.
Well, as you will see in my retainer, and most retainers, I determine the legal decisions. I make the legal decisions. You want to get an attorney? Go for it, but I make the legal decisions. And there's no way in hell I can take that trial. And I lose. I lose time, and I lose money. I might have to deal with the medical providers who are upset at me because they were on the lane and they don't get any money. They overbill me anyway. So you lose.
Can you recoup any of your expenses based on the money?
You can. It's more time and money. They don't have money. You're going to recoup your cost of whatever. You recoup costs. You can't recoup the attorney fees, but you recoup the costs. The costs are the filing fees, anything that you pay out of pocket. But it's just like, it's not going to happen. It's a waste of time. Unless you like out of pocket like 20 or 30,000, even 10, and you think you can get it back from the person. But out of it, no, a couple thousand or a couple hundred, you just eat it and walk away. So this is the initial client report. This is what we're doing. We want to, we get the defendant's insurance. We look at any past illnesses, the history, because those will go to mitigation of damages. And this is a personal injury report. Okay. Any questions on this? Yes, sir.
You have the military on there. Is that to say they have prior injuries in the military? Is that for the obviously the prior injuries with the record?
It's for purposes of prior injuries. It's also just to get a history of like, do they have medical? Do they have any VA benefits?
If they do, then what does that impact?
Just depends what type of case, but on a pure personal injury, wouldn't. I mean, they might want to bring it up and say, well, he could have went to his own doctor at the VA and not to pay anything, but he went to the doctor that the attorney referred him to, and they can say that. But I would. All right. Any questions regarding that? The client injury. So let me see another one, sir.
So let's say you would make that argument, right? And it seems like sound argument.
It possibly could. I never represented a person in front of benefits, but obviously you can make the argument that to say that, yeah, we need to get him in there right now, and he couldn't get in there right there with his VA benefits. I mean, but they, at the same time, they can't pick what doctor you go to either. They can't make the argument. You just always kind of, you can't say, tell me what doctor you go to. This is an employment intake questionnaire. A little different. It's all the same basic information. And this one you might want to streamline the type of case because it's a wage and hour is discrimination. You don't need to know wage and hours, right? If it's I think this is a wage and hour overtime conversation. Yeah. Well, yeah. I mean, if it's a wage and hour case, this is. I'm just looking at. It's a wage and hour. Yeah, this is helpful. But if it's a discrimination deal with employment, you don't want to ask them about wage and hour stuff. So you want to make sure that your interview is on the topic of the case. And so, you as paralegals, what do? Logistical stuff. You set up the interview. You make phone calls. You get all the background information beforehand. So if I'm going to the interview, then I know at least I know what I'm talking about. I don't want to take a blind interview. I don't want to waste my time. So you as paralegals, you would do all that information, do all that work. It's very helpful if you guys are the screeners. Right? I was talking to a client, a potential client. He emailed me. Never done it before. Started them. Wage and hour, example, classification, overtime, etc. Paralegal called him because when I called him, he was just. I was like, I gotta go. And I needed her to screen it and get all the background information possible. That's what you guys do. All right. What is civil litigation? So civil, this is not on your PowerPoint. Don't worry about it. Write the notes. Listen to me. It'll all match up. Civil litigation is resolving legal disputes between parties. So in criminal law, you had a plaintiff, you had the government, and the defendant. In civil litigation, you had the plaintiff and the defendant. The plaintiff could be either individual or business. The defendant could be either individual or business. If anybody had a lawsuit, know someone that had a civil litigation lawsuit. What? All right, good. You guys the plaintiff or the defendant? Anyway, and the reason why you don't want to sue individual defendants, they don't have deep pockets. Litigation is about money. So we resolve a dispute, but litigation is about money. Why won't you apologize? Well, they will apologize when they pay you. Right? I've been doing breach of contracts on the hearing injunctions, but litigation is about money. I mean, don't miss it at all. We were representing the plaintiff. We're trying to resolve the dispute. One way we resolve the dispute is by getting paid. Hey, I don't want to BS you guys. I know I fight for my clients' rights, but at the end of the day, they're happy when they get a check. We settled yesterday. I had a mediation for 9 or 10 hours on Monday, a case, and we were able to resolve it. And so they're going to, just like we were, case kind of fell to the craft. There were some things that came up later. Fine slot. But regardless, we got it resolved and we got a check. And well, they were wrong. They did wrong. And this is what my client's telling me. And I'm like, I just listening. They're wrong. They're wrong. They did me wrong. Yeah, they did me wrong. I'm not supposed to even know. Okay. When the check came, or when the check comes, she's happy. This is how they apologize. We're sorry for doing you wrong. Take this money. Nobody's going to say sorry. Even the settlement agreement says we didn't do anything wrong, but we're going to pay you. That's how crazy it is. That's what the settlement agreement absolutely says. We're not saying that we did anything wrong, but we're going to give you $1 million. Right? And who settled? Who settled before? Yeah. You guys read your settlement agreements? What does it say? We don't admit to any liability. We don't admit to anything. But we're going to give you this $20,000 check. Yeah. Well, at least not on this issue. If I don't ever have to see you ever again in this issue, right?
Also, that's dependent from other possible parties following for the same purpose. So if you can admit
parties. If there's multiple parties. But the settlement agreement is not going to be admissible as evidence. I mean, so nobody, no one from that party can actually say, "Hey, use my settlement agreement for your new case." They admitted liability. So it's kind of funny. I always like reading the settlement agreement. We don't admit anything wrong. We're going to give you this really, really big check. It's kind of funny. All right. So it seeks a remedy for a civil wrong, which is a tort injuries, breach of contract, or you look at it in any type of civil dispute. What is one of the differences? What are some of the differences between civil law and criminal law? Remedy. All right, punishment. So we're looking at money. Jail. Go ahead. Oh, I love it. What do we got? Good. Preponderance of the evidence. And what's the one?
Reasonable doubt.
Yeah, reasonable doubt. Don't read my writing, listen to my words. Preponderance of the evidence. That's the evidence. And beyond reasonable doubt. All right. So, why is there different standard of proof? Are we talking about this?
Yeah.
We're talking about this, right? If you find you wrong in civil, you gotta write you a check, small big. If you find you wrong here, you're going to jail. In life and liberty away, probation, fines, right? Death, solitary confinement, right? Solitary confinement, like cruel and unusual punishment in some capacities. You make somebody stay in jail in that area for that long period. Shouldn't that be like cruel and unusual punishment? I'm not a criminal law or criminal procedure master. It seems really effed up. They deserve it. I'm talking about years of solitary confinement. Not we're gonna rest in solitary confinement. I'm talking about you're going to be put in solitary confinement because you're not a good person. It's like an amendment violation.
Regardless of people's emotions about it, it is something that's actionable as a civil rights violation.
It's actionable, but the courts have found that solitary confinement is not in violation of the Eighth Amendment. So you remember that because people are still in solitary confinement, right? So anyway, I was talking last night in my class. So real estate law, civil procedure, and civil criminal procedure, and criminal usual for solitary confinement. All right, give me another one.
The plaintiff,
Parties.
the person is suing in civil and in criminal, the state is bringing the action.
This is plaintiff. You guys understand?
Yeah.
Some people haven't. I signed plaintiff, and I was told this, and I'll give it down. What you guys say about this? I know it's by the end. I forgot. This is triangle. Exactly. They call it a devil. It's a damn triangle. The triangle is the defendant. You got the pie and the devil. You got the claimant, and you got the triangle. What else? Differences. We got the parties, we got the standard of proof, we got the remedy.
Wait, who's your freedom? And who's your freedom in civil?
This goes like the punishment in the remedy. Like them. Yeah, like liberty.
Okay. Well, you can't really appeal anything on
Feel everything. You can feel motion rulings. You can feel the murder hearings. You can feel everything.
So if somebody is found, that they are civilly liable for someone's injury, then they can appeal it.
Indigent people.
Well, I thought that was
But there's a way to say, judge, no way of saying,
I don't want to say it's always, but 95%. Because if there's no threat of death, there's no, you're not going to jail, you're not always entitled to. If the punishment is not jail, you're not entitled to. Okay.
but you really can't say it all.
I don't know if that's really correct, but
No, I mean, there's nothing, their judgment.
well,
Well, all criminals are bugs, though. Some criminals do have some money.
You know, like if they,
well, I get like $10 today. I'll sue his ass. I think he hit me up for like every time in the same place, and I just forget that it's him. So he probably got more money than me right now. I've been giving him money for years. I would sue him.
every once in a while, they really aggressive.
I'm trying to. All right. So these are some of the similarities and some of the differences between civil procedure and criminal. Right? We talked about the role of the paralegal. You're collecting information and evidence. This is in your client information sheet. This is the sheet that we went over. Organization. You're going to analyze the facts of law. So when you get the facts, you're going to look at the claim. You've got to identify the causes of action. Right? This is why I mess with you guys about what are causes of elements of negligence. Because you have to identify those elements, and then you have to take these facts that you got from your client, and you got to make a match. We have an approved case. All right. Briefly, the law of structure deals with attorneys, paralegals, administrators, legal assistants. These are all members of the team, associates, and partners. And for the purposes of attorney-client privilege, everybody in the law firm, the attorney-client privilege expands from the client. I'm talking about the case with an associate attorney, attorney-client privilege. Very client, and I'm talking about the case with the paralegal, attorney-client privilege. It probably or most likely will not extend to the receptionist, especially if she's doing he or she is doing multiple jobs in the law firm. Then they would extend to him, but he or she is just the receptionist, and it doesn't have any responsibility on any of the files. Then I don't think that the attorney-client privilege extends to her. Or him. I'm sorry, I keep saying her. That's not. I'll show this. That's my law office phone right there. Central.com. All right. We talked about client relationships. We talked about the manager. So, what are your responsibilities as paralegals? It depends on the law firm. The bigger law firms, you're going to have strict duties and responsibilities. Get the mail, type in the information, work on the case. It's going to be very strict. Smaller sole practitioners, you're going to do it all. You're going to be the paralegal, the receptionist, the file manager, the attorney. You're going to be the coffee getter, the lunch maker, whatever. You're going to do it all. But I think that if you get an opportunity to work at a small, as an intern at work at a small law firm before you go to a bigger law firm, you learn a lot because you have to do so much. You actually have to work with files. And I know, Allison, you said your law firm. How many people? Okay, so pretty big. At your law firm, you get to work files, which is kind of cool. But when you get to like these Jackson and Lewis's downtown, where you got 500 attorneys, and you got a niche. You got so many files you come in, type in. I find that you don't get to really. You want to practice law, you're not necessarily practicing law. Those type of law firms. It's luckily Allison, a law firm allows her to actually practice law instead of being this administrative filer. Nobody wants to be a filer. You don't want to be a coffee maker. Okay, so if you get an opportunity to intern at a small firm, you get some hands-on experience with actually drafting stuff, preparing documents, and responding and reviewing files. I would suggest that you take the opportunity. So, tracking deadlines, you won't be monitoring budgets for the most part. You will be reviewing documents. You will be calendaring. You have to identify what calendar system is being used, which is very important, knowing a particular system. So many things are due. It's a very important responsibility. You'll be meeting with the attorneys or the attorney to go over cases, to identify what needs to be done, what's next, to talk about strategies. I like to bounce things off my paralegals. I just want to hear a different person think. I like to bounce things off my classes that are paralegals in it, or to be paralegals. I just want to see how lay people would hear a case. I don't want you to look at it like an attorney. I want you to look at it like, oh, that sounds like a stupid case. Oh, that sounds like you can win. Oh, this is and that's what you will be doing in-house at a law. And that's why it's good for you to educate yourself with the elements of negligence, the elements of battery, assault, the elements of to form a contract. What do you need to form a contract? Offer, acceptance, consideration, capacity, legality, legal consent. Tattoo it on your arm or your neck somewhere. Just take it right next to the elements of negligence. The statute of fraud to me. These are things like these concepts, you hear them. I'm not going to use it. These are things that we use. Statute of frauds. Statute of frauds. I'm talking to Becky. All you helpful people. Statute of frauds mean that contracts have to be in writing for them to be valid, right? What contracts have to be in writing for them to be valid? My legs. Use the acronym. My legs. Okay. My legs. This acronym I used to take in the bar. That's my third time I learned it. So, it's hard. All right. My legs. Marriage. Years of service or employment over a year. They can't complete in a year. Land. Executorship. G selling goods for $500 or more. That's suretyship. My legs. Suretyship. I'm assuming you did have a third party. Assuming you did have another person. Yeah. Years of service or years of employment over 1 year. Marriage. Years of service over 1 year. Land. And executorship. The executor of an estate. The sale of goods for $500 or more. And a suretyship. You assume you did have a third party. My legs. We get so much information as attorneys and paralegals. We try to try to condense it so we can remember some of it. Right? The reason why I have open book, open note, final is because you need to be. You're going to have everything is going to be there for you to find. You have to be able to apply it. You have to find and apply it. So I say, open your book, open your note, and get it. No laptops for final. They won't let you guys use it. So you have to get your notes off. If you have a book on a thing, sorry, they won't let you use it. Take
home 4 days later.
Maybe we should look at the syllabus. We'll look at the syllabus and then we'll do our this is what I do with my syllabus. I give it to Voltaire. Then Voltaire destroys it. Assignments. Hold on, you guys. Maximum 5 extra credit points. Okay, students can receive no more than 100 points. Rating policy, written assignment, classroom. Oh, classroom policy, very important. Behavior record. All right, here we go. All right. Where?
page, it says when the paper final is due. First we have the instruction on the, I think it was page 2.
Yeah.
It says that table final will be,
April 17th.
That's part of your grade. That's half your grade. That's the actual practical assignment. I think I was.
Example, handing out.
13/7, 6/13.
This is no words. I'm not gonna lie. I'm not gonna lie to you guys, and I won't put you at a disadvantage. The practical assignment is the take-home part of the final. It's half of your final grade. I think that's why you're kind of drafted like this. There is a final exam, which is in the class, without the class. Okay? I mean, so, yes,
What percentage?
50 and 50.
50 and 50.
Yes.
That's not so
Well, I'm just confused with you mentioned that the practical assignment is next Thursday, not saying no difference to review on Wednesday, it's due Thursday. Now you're saying it's not due until following week according to. Yeah. So I'm just confused on the actual due date of the practical assignment.
This was drafted for the class, and when I gave it to Voltaire, obviously you got something. The practical assignment is due the last day class. And I go back and change it. I can't make it due 4 days later because I mean I have to come back up here. There's no way you give it to me online or the other way, but you mail it to me, which I don't want you to do because I don't want to get 50 books in my house. So that's a mistake. I won't put it on Voltaire. I like Voltaire. I apologize. Practical assignment is the last day class.
So we're not taking anything.
Practical assignment. You're taking the practical assignment home today.
We're not giving this anything on the last day of class to take home and hand it on the 17th.
No. Okay. Practical assignment is due the last day class. Final exam will be in class on the last day class. So you bring your practical assignment. It'll be a big brown box. You put it in there. And then you'll sit down. And then we'll review a little bit. And I'll tell you, these are the questions that are going to be on the final. And then you'll open your book and your notes, and you'll take the final in class that day. So that's a change to the syllabus, and that's my fault. Blame me. Blame me. Blame me. Blame me. I won't change anything. I'm not going to give you 4 days to get a final exam. It's more than it's true or false. It's like, seriously, seriously, I think it's all multiple choice. It's easy. Easy. Super easy. I'm gonna probably give you today. I probably give you a practice exam on Friday and Monday. It's like easy. It's open book, open note. How do you
Second guess yourself.
And so the practical assignment will be half your grade, and then the final exam will be half your grade. And then you have the 5 extra credit points, which is really easy to get to the deposition subpoena. Any questions? Sorry that I know you guys are real stickers on the syllabus, which is really funny to me. Sorry that I had to change it. No, the morning classes for some reason are always real stickers on the damn syllabus. The syllabus says this. Okay, change it.
Your syllabus will always be correct.
Yeah.
I'm not bringing up anybody. I made the mistake. I'm at fault. You have not been put at disadvantage. At all. At all. The only thing that you can be disadvantaged by is if I allow you to take the final exam, which is the practical assignment, and have it due 4 days later. The only thing that you will be disadvantaged is I will be pissed when I have to back up here to pick it up. So when I'm grading them over a glass of wine, I will be pissed while I'm grading. You want me to be happy when I'm grading. See, I'm trying to negotiate with you.
Yeah, that's all I got.
Right.
I try to get this fixed so people who are here to get it. I try to get this cleaned up. But this is what I'm telling you. The practical assignments we'll do on the last day of class, and we'll have a final assignment in class on the last day of class. I think it's just the wording and we just missed each other. All right? Sorry. Somebody had to move the cards at 11. There's 11 or 11:15. We moved it. Anybody else got to move across? All right. So what I do is I'll probably give you a practice exam. It won't be working on Friday. Another one on Monday. It won't be working points. But it'll be basically based off of the lecture and what you've read and see if you're retaining anything. And then some of those questions usually are on the final. So it's good to be here. All right. So with partnering, paralegal partnership is the most successful when their work happens in personality, harmonizing, and complementary. Yeah, me and my paralegal trust each other.
That works for you.
You know, it's a real relationship. You know, it's just me and her in the office, and go do that. You go do it, all right? And I'm the one saying, all right. She doesn't ever listen to me. No, she's a really good paralegal, and I've had some really good ones over the years. All my paralegals that I've hired have always been students of mine, and so I know what their skill set is. And most of them have been women just because they manage to be better than men. Just women just tell me when I kind of listen. We got that, you know, so. Chris, you need this motion real quick, you know. So, but I found some men to be very, very rational paralegals. Okay, so I had a senior paralegal, his name was Butch. He was, not really was his name. His name was Milton. They call him Butch. And at the old firm I worked before I started my own, and he called him Butch. Before he became a paralegal, they didn't have all the paralegal schools and stuff. He was a women's lingerie salon in New York. We call him Butch, right? That's classic, right? All right, so that was good. He knew the brother's guide in the rules of civil procedure like no other human being I've ever met. You know what the brother's guide is? That is the Bible for civil procedure. It talks about all the dates, all the cases, the brother's guide for civil procedure. All the dates, all the cases, it talks about everything what you can and can't do. And he was the master of the rules. Women paralegals, not so much the master of the rules, but very organized, very smart. So this is just my experience. I'm not saying that you guys aren't, not male chauvinist or nothing like that. I think women are better than men in the world in life. Okay? There's more women in the class than men, you guys. I thought you guys had. Okay, but I'm saying. So we have to be organized. We have to work together because we work to one common goal, and that's to get the best result for our time. Know the facts. I hate when you don't know the case. When I ask you something, you say, huh? What case is that? It drives me crazy. Do your due diligence. If I got to remember everything, so do you. And that makes you that much marketable as a paralegal. You got more value in the law firm, and you're going to get a raise, you're going to get a better bonus, and you're going to get more responsibilities. You know, it's not like, it's a perfect example. Aaron Brockovich. She is a multimillionaire now because she did her due diligence, because she wanted more to represent her clients, to represent these people, to represent the law firm. She went out there. You have to be hustlers, you have to be go-getters. Now, the bigger firms are going to make more money. You're going to make 60, 70, 80, maybe 1,000 at some point in your careers. Smaller firms, you're going to make less money up front, but you might get a bigger bonus based on what cases settle or how you work the cases. You're going to be happier at a smaller firm because it's not 10 hours a day every day. I call for Fridays, my back's not hurting, so my paralegal doesn't have to come in. You either one, you just go kick it. I mean, you know, you work at the bigger firms, you're going to be there from 8 to 6. You just have to maybe 8 to 7. Now, that's not always how it is because this weekend, her and I both came in on Sunday. We had an opposition motion for summary judgment, and we had to work on 200 pages of documents. So, you know, what you can take. Like I said, it's just a preference. You get more money at the bigger firms, Less of this partnering, more money, less partnering, less. What's the word? I would say to have less discretion, smaller firm, less money, lot less money. Possible more money on the back end cases, the big case settlement, bonuses, more vested in actual work that's being done. You feel like a law firm is yours. And it just depends on what you want to square lives. It varies. I left the law firm because I got tired of working 12 hours, 10 hours, and not getting the pay that I thought I deserved. It's a lot of hours. It's just, I want to say, I can make some money, but that's money to do it myself. And I have. And so, it's just what you want. You need to become familiar with the courthouse system. Let me help you become familiar with it right now. If you haven't been to this website, go to it. LASuperiorCourt.org. LASuperiorCourt.org. LASuperior.court.org. No. Who's been to this website before? Everybody, tomorrow, let's have everybody hand up. Let's go through, just have some fun with it. All right. LASuperiorCourt.org. This is civil, general information, case summaries, calendars, courtroom, tentative, complex, collections court, limited civil court, personal injury court, unlawful detention court, blah, blah, blah. Finally, forms. All right. Click the form button. All right. These are the forms. You will find this. We all get the website and we just kind of read stuff on it. It's important that you read stuff on these websites, on these pages. You will find links to the forms you need to file your civil case. A list of Los Angeles Superior Court local forms you can use with your Los Angeles Superior Court case is also found here. We have to have local forms for our project and for Los Angeles Superior Court. For our project, I'm giving you this. Civil case, cover sheet, addendum. And you go figure. This stuff is in alphabetical order. A, right? A. No B's. C. Civil case, cover sheet, addendum. It actually says the word on it. Civil case, cover sheet, addendum. Yes, ma'am.
Are the actual civil case cover sheets found in a different spot?
All right. This is the addendum. Short title of a party, you got the last names. Things Fingers versus Bubbles, or if you're doing it, I don't know if you're suing on behalf of the corporation in your fact, the corporation versus whoever, I don't know, I can't remember. It's the last names. It's individuals. No case numbers on any of your documents. It's not filed yet. Don't make up your own case number. Don't do that. We're representing the plaintiff firm, so let's do a jury trial. You want a jury trial, but no class action, no, it's limited. Well, what's limited? Bracketed. Under 25 and what? What's the load of 10? Okay. So you have small claims, but I think they're raised 15,000 now, right? 7,512. I thought they raised it because they had budget cuts and so they had to implement new rules. Somebody who's over here, look it up. Okay. Well, please look it up. I believe, I thought it was 7,500 to 10,000, and then they raised it because of the budget restrictions and they revamped the court. So they had to make it bigger. But maybe I'm wrong.
Yeah, it's 10,000.
Okay. So limited ceiling is 25, bottom is 10. So you can limit it to 10 to 25,000. So if your case is dealing with a monetary value between 10 and 25,000, you could limit the case. And the reason why you do that, it goes to a different courtroom. And then you estimate the time for trial, days and hours, depending on what the case is. I don't care if this number right now. Just don't put 20 days for the case. Probably 2 will do it, 1 will probably do it, 3 may do it. Just make it simple. So you estimate time for 3 and days. Read the steps. This thing is really easy. Read the instructions on it. If you don't read the instructions on it, it's not easy. It just, if you don't read the instructions on it, it looks really hard. I mean, look at it, we read the instructions, kind of like, what the hell are you talking about, right? It looks hard already. Read the instructions. This is a civil case procedure. I'm not going to go through each document. I'm not going to go through each part of it. I want you to kind of struggle at it and learn for yourselves. I will look at your drafts. But listen, you need to have. I'm giving you the documents that the court says you need. Look right here. Please have the following items completely ready before filed in the order properly mentioned in the case: complaint, summons, civil case cover sheet addendum, civil case cover sheet addendum, money. You need a guardian ad litem, which you want. Any additional copies you need. You have these original complaint, summons, civil case cover sheet addendum. Some of you guys should be looking at this document, writing down the actual number document. If you want to find it, I'll show you. If you want to find other forms, this is the way I do it. Other people do it this way. Other way, or California website, just click this. You can go to it. You can type it. I think it's www.courts.ca.gov. www.courts.ca.gov. And these are the forms used statewide. I always do forms listed by name because I'm just a creature of habit. I probably know them. I'm just a creature of habit. If they're listed alphabetically, I just know where to find them. Okay, so civil case alphabetical order. C-I. Civil case cover sheet. Make sure you get the right one. Put the attorney information up here, phone number, the court, street address of the court, 111 North Hill Street, right around the corner. Case name, if it's limited or limited, so you just click boxes. And you guys really will do all of this stuff. This is something that you actually really don't love. Check. Don't do this, please. Check one box. Don't check two. You're looking at me like, of course, let's just check one. You'll be surprised at the percentage of students that actually check more than one box. It says check one. Pick the best one. And then your case is not complex, so we want to check a non-complex. Complexity deals with these issues: large number or several represented plaintiffs. That's when we have joinder, extensive motion practice. We have a class action. Witnesses are from out of state, or really difficult type of issues. Those are all type of complex cases that are filed up here off of Central West on Wilshire. What's it, 600? 600 Commonwealth. Those are complex. We file that. Monetary. You list you don't number cause action is 1, 2, 3, or 4. You don't have to write out the name. Just put 1, 2, 3, or 4. And it's not class action. I'm doing the work for you guys. Stay with me. So we found a civil case cover sheet. The next one is what? He looks good. Summons. Alphabetical order. Now it's a whole bunch of these damn summons. Pick the right one. Don't do any of these. You lose all the endpoints. That seems so slow. So all right. Summons. Notice to the defendant. If the defendant says, I got 5. So this. If your caption to your complaint, you have to draft the caption, the pleading caption before you do the summons. But it says on your caption, it has to look exactly like the summons. The summons has to look exactly like the caption, you guys. If you have those, which you all will, those are unknown defendants, DOES. Those are unknown defendants, like John Doe, the unknown. You will put the those in there as well. You have to put it exactly like the caption. case, I probably would get 13. I mean, it's no rule on how many doses you have because they're dismissed at some point anyway. But the purpose of having those is if you need to bring in unknown defendants who are not known at the time. So through your research or through your discovery, you find out, oh my God, there's 100 more people we need to sue. And you only have 50 of those, you're SOL. Should I look? I don't know if you guys check right now. One more.
Can you have those?
No. But at a later point, if plaintiffs want to join in a lawsuit or the plaintiffs need to be joined because they're indispensable parties, then they will be joined. This is the summons. Make yourself familiar with the summons. Complete it. Read it. Name and address of court. Stanley Moss Courthouse Central, 1 Avenue North Hill Street, Los Angeles, California, 90012. Sad, I know. But you usually remember too. Really sad. Stanley Moss Courthouse. Alright. And this is the summons. So you know where to find all these documents, you know what to do. And now, just the last one. Yes, Angela?
You'd rather us write Stanley Moss than Central?
I would rather you write Stanley Moss Courthouse, Stash Central. That's what I would rather. If you're wrong, if you do it the other way, no. That's my preference.
That's what I want.
And the last form that we'll have, hold on for this. Proof of service. The last one. This one always. This is the one I should be looking for. POS 010. Okay, fill it out. Same type of heading up here. At this point, you would have the case number. However, don't put the case number in. When you have the proof of service, you will have the case number. And we're going to check these boxes. At the time of service, I was at least 18 years of age in my parties of action. We're going to check this one and this one. But the reason why we don't check the civil case number sheet is it says served income tax cases on it. You won't lose any points if you check it. You just ignore me. Remember, how many people is it? 25. If you're like the 30th person and I'm annoyed, you're getting a bad grade. So let's try not to annoy me when I'm grading these, okay? And line. Make sure I have one. That's good. Angela.
Why are we serving the ADR package?
We don't have it, so we can't serve it. If you have it, then you serve it. Yes. They do. It's private. When did I file? I filed like new cases, and we did get an ADR package, but I think that had to be. That may have been April. I don't think they had changed it yet, so we still had some ADR packages that we get out. Or maybe they're early selling. I can't remember where they were, but they were giving them. They gave them out. So when you file, the clerk gives you back your document with some ADR package they used. I don't know. I haven't filed in a couple months. And you're supposed to serve that with the defendant. Sometimes I do. I'm giving you guys real life here. Sometimes I do. Sometimes I don't. Depends on who the defendant is and what I think they're going to do. You know, it costs money to put extra papers in here when you're emailing stuff. I'm trying to give you guys a real life perspective of litigation from a solo practitioner. And I don't have $7 every mailing to go out for ADR packages. We'll talk about it. But if you have any documents in there, you click it. All right. If it's an agent for service process, you put the information here. Make yourself familiar with these documents. I don't want to go through them each one, but make yourself familiar with them. It'd be very useful if you know back and forth these documents as litigation paralegals. That's the field you go into. Yes, sir.
You mentioned Butch. You have the runner's guide.
George?
No.
Butch. I like Butch.
Runner's guide. What was the other thing?
He was really good. Of course, the rules of procedure, the core rules. He was good at everything that dealt with procedural stuff. He had a really good mind for law. As a prior non-direct seller. the weirdest thing ever. Alright. No, I'm not going to use that again. Got me in trouble first. Alright, form interrogatories. You know that name tag, but you're going to get back, right? Alright, Joe. Mike. Last form is the form interrogatories for civil. If it's limited, use the limited ones. Okay. The rules of the discovery rules are different. If it's unlimited, use the general. Again, if your case is limited, you can make a determination yourself when you look at it. If your case is limited, use the limited 4 rods, which are these. If it's unlimited, use the general. Has anybody seen these documents before? I'm not very done. Any classes or just like a lot of you haven't though.
No.
Perfect. I just want to make sure I'm not going to a lot of you. All right. This is a form interrogatory. Has anybody been served with form interrogatory? Yeah, all right. Read the information again. This is very generic information. Once you get it down the first time, just copy and paste it. Honestly, it's not that hard. Or you just type it out. Short title, Los Angeles Superior Court, blah, blah, blah. Form interrogatories. The asking party, we're plaintiffs. So we're the asking party, plaintiff, whoever it is. By this time, we'll have a case number. However, if you want to make up one or don't want to make up one, I don't care. So you. Answering party is the defendant. Defendant. Well, I can't remember the part. Okay. That number is 1. This means that you have one set of discovery. This is our first set. Form special RP, RFA, notice deposition. This is our first set. We're served together. You can, and later on, later point, you can have a second set. You can possibly have a third. At some point, you probably get a protective order or a motion if you keep serving them with discovery. Read these instructions. I don't read them at all anymore because I read them all the time when I was in your position as a law clerk. I don't want to read them anymore. All right. I will grade you if you don't check the boxes. If you just submit a form interrogatory with no boxes checked, I'm going to grade you. Yeah, you're going to lose points. Now, I'm going to tell you generally what boxes. If you have an individual defendant, check all of the individual defendant boxes. If you have a corporate defendant, which I don't think you do. No, I don't remember back better. Regardless, if you have an entity or business entity, check the business entity boxes. So these look, this is general background information. Individual. So don't say what boxes do I check. The ones that say individual, go through it, check all those. Even if you think they're not applicable, check all the individual ones. If it's a business, 3.0, check the business. Always check insurance boxes. Always check insurance boxes because we want money. Insurance has money. Individual or defendant. I don't believe that there's going to be, you're the plaintiff, so we're not checking the physical or mental or emotional. You read these, you're like, well, that's not applicable. So you actually have to read them. That's why I'm trying to get you started sooner. Read them and say, is that applicable or is it not applicable? I'm heading away. All right, my bad. All right. Loss of any, property damages, probably not applicable. Loss of income or earnings, probably not applicable. But you have to read and make that determination as paralegals in my law firm. I'm not going to hold your hand. Well, I won't hold it anymore. All right. Any other damages, medical history, make a determination. Okay. If you're going to check them or not, probably not. Always check investigation. 12.0. Check all the investigation boxes. You want to know who they know, what they know, and how do they know it. That's how you get that information. Investigation boxes. Okay. Statutory regulations, maybe, maybe not. Always check 15.0, which is identify any denials, special or affirmative defenses that you have. Tell me about your case. Why are you challenging us? Okay. Personal injury. This is not a personal injury case. 13.0 is investigation. Check that. I'm kind of going fast. I don't want to give you all the answers, okay? But I know I'm doing what I'm doing here. I want to go fast. I want you to figure it out. Always check 17.0. It's probably the best used interrogatory when you serve a request for admission. This interrogatory asks, is your response to each request for admission served with these interrogatories an unqualified admission? Okay. So a request for admission says, admit that your name is Bubbles. If they admit it, you don't have to prove that at trial. If they deny it, then you have to bring evidence at trial to prove that the name is Bubbles. So, and that's a very basic concept, but just think about it. If you say, admit that you crashed into the back of me, personal injury case. If they admit it, you don't have to prove liability because they crashed into the back of you. And so what the request for admissions do is they kind of narrow down what you have to prove at trial. If they deny it, which they're smart, most people deny everything. If you ask me my name on a interrogatory, I will deny it. Just prove it. Right? Prove it. Yes.
I'm a little confused because I'm not familiar with former interrogatories. You're a plaintiff. You're sending all these pre-packaged questions to the defendant, and basically you're making them answer the ones you check.
Yes. Same thing if you're a defendant. The defendant serves the same documents on you.
Well, how can you deny your name? Say, that's not my name. That's perjury. It's like, is your name?
It's not Chris Elson. It's Christopher.
Well, is your name Christopher Elson? No, it's Chris. I mean, that's perjury.
No. I'm not lying. It's asking me to admit. I have to admit it. You're not at a deposition. You're not at trial. I'm signing these under perjury, but it's asking me to admit something. I'm denying it. It's standard practice. Standard practice. Denying everything. General denial of everything.
Well, it's like when you get a traffic ticket, just agree to meet in court.
I don't know if I can make that correlation. Let me see. Well, no. Michael, I'm come back to you.
I was going to say because sometimes because they fail to make
traffic. I'm not with the traffic ticket correlation yet. I'm trying. But in the sense of denying, it's different in civil court. Civil court, when you deny, I'm talking about request for admissions. Okay. It's saying admit that you're. Well, I think I said it was a bad example because I probably would admit, but you deny everything. Admit that even if you crashed into the back of somebody, admit that you crashed in the back of one and are liable for damages. Deny. Make them prove it. That's standard practice.
Well, you don't just flat out say deny most of the time, right? There's a little saying that goes along with it, like based upon blah, 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 blah. To the extent that the party is looking at that, you deny.
No, not request for admissions.
No?
And in discovery, it is say admit that your birthday is today. You can admit it.
Well, just for your birthday, but I mean, when you ask more substantive
The
questions.
question is asked on request for admissions, admit or deny.
Yeah.
Doesn't ask, you don't get explanations ever.
To the extent that the opposing party is seeking whatever.
I would object based on making ambiguous and cop out.
No, I'm saying it's something.
So if we can do this more specifically probably on Monday or Tuesday, but in responses to request for admissions, all you do is admit or deny.
You don't object.
Well, we were talking about what you were saying there.
You object based on blah, 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 and then you say,
If there's an objection that is applicable, then you would object. Let me just, for you guys who are not understanding, I'm going to try to give you, I'm going to see if I have one of my documents so you can see it. Yes.
How long does the defendant have to respond to your
30 days plus 5 if mailed. So if you personally serve, you have 30 days to respond. If you by mail, 30 plus 5.
regardless of the case, personal injury,
Regardless of the case. Correct. Plaintiff or defendant. So if the defendant serves you in discovery, you have 30 plus 5 days. If the plaintiff serves you in discovery, you have 30 plus 5 days. If it's by mail. Usually by mail. Personal service, you have 30 days.
For any of these questions, do you get to add some questions, or must you stick only with their brief?
You guys are getting ahead. I'm a.
I can think of a lot more questions.
We're all getting ahead of ourselves, but it's fine. This real quick. These are, I just was kind of just showing you what the forms were. But it's a good question. Oh. Don't give it. Robert looks. Look at me. I got your back, Robert. I got your back. So, these are form interrogatories. Okay? These are another form that you'll find on LA Superior Court or that website. 17.1, you have to check is very, very applicable because if they deny your request for permission, then they have to give you reasons why they deny A, B, C, and D. It could be a very useful resource, useful tool in the form of derogatories. That was the only part. If you have a case, so those are the ones you have to. This is not a car accident. Breach of contract, I believe it is, so the 50s will be applicable. Right? That's a form of derogatory. If you don't check 17.0, I'm going to put a big red mark on your picture. We spent 30 minutes on it. All right. Can I put this one on? All right. Just let 30. I need a second break. Take a 10-minute break. If people want to ask questions, stay. We'll take a 10-minute break.